Hello students, welcome to lecture number 8 of Constitutional Law lecture series. In the Clat lecture series sponsored by Srijendra Rengzon, I am your mentor Shekhar Galot, Clat All India PG, rank 25. So we were discussing about the functionaries in the Constitution of India. Now we are discussing about the Attorney General of India. We have already discussed about the ministers, Prime Minister and the Chief Minister, Governor, President, Vice President. Now we'll go to another important functionary of the Government of India, that is Union of India. We have Attorney General of India. Okay, Attorney General of India, and his counterpart, that is his equivalent in the state, is called Advocate General. Advocate General of State. He is basically an advocate who represents the Union of India, or Advocate General will represent the state government before the High Court or the Supreme Court of India. He is the first law officer of India. Attorney General is the first law officer of India, and AG, that is Advocate General, is first law officer of state. Okay. Appointment: they are appointed by the president and holds a post during his pleasure. We can say, so AG is appointed, Attorney General is appointed by the President of India, and Advocate General by Governor of State, and they hold, there is no fixed tenure for them. First of all, no fixed tenure. Both of these do not have any fixed tenure, and they hold their position till the pleasure of the President of India or the Governor of the state. That means till the time President or the Governor do not remove them. And when will the President or the Governor remove them? Only on the recommendation of PM or CM, as per case they can be removed. The qualification is must be a citizen of India, must be eligible to be appointed as a judge of the Supreme Court of India. Okay, he must be eligible to be appointed as a judge of the Supreme Court of India. That means he should have been an advocate for at least 10 years. Someone who have been an advocate for 10 years of at least 10 years of duration, he can be appointed as a Attorney General of India or the Advocate General of the state. Term of the office during the pleasure of the President of India or the Governor of the state, as we have already discussed. Removal can be removed by the President upon recommendation of the ruling party. No confidence motion passed by the Lok Sabha. Okay, no confidence motion is passed by the Lok Sabha against the government. When the government lapses, he will also lapse. He will also resign by the government, with the government. Why? Because he was appointed by the government, which does not enjoy the confidence now, or we can say state legislature, state assembly. Okay, so they both have exactly similar functions. This Attorney General is for Union of India, Advocate General is for the state. They have exactly same procedure of appointment and removal, and have same powers, he for the union and he for the state. Functions: advises Government of India on all legal matters, defends Government of India in all courts of law, has the right to audience in the courts of India, has right to appear and defend the government in either house of the parliament, does not have a voting right. Okay, so Attorney General or the Advocate General may enter Lok Sabha or Rajya Sabha, or in case of AG, State Assembly, and defend the government. Okay, so many times discussions are going on over the legal matters in the parliament or the state legislature, and when the state feels or the parliament feels, sorry, union government feels that they are not able to explain the legal position properly and they need a lawyer to do so, then they can ask the attorney general or the advocate general as per case to please come join the proceedings and explain or educate the other people, other members about the intention of the government. But when they enter into the parliament, they can take part in the proceedings only. They do not have a voting right. Why they do not have a voting right? Like we discussed, only elected people have a voting right. Other functionaries, Comptroller and Auditor General of India. Okay, and for state we have Auditor General State. Auditor General for state, and for the union he is called this post is called Comptroller and Auditor General of the India. He is the highest accounting officer of the India, just like AG is the highest law officer. He is the highest accounting officer of the India. By name it suggests he is going to audit, he is going to do audit of the union government. He is the guardian of public purse. He is also called guardian of the public purse because this government uses public money, and CAG, he is also called CAG in the short form. C for comptroller, A for and, auditor, sorry, C for comptroller, A for auditor, G for general. CAG, because government uses public money, and CAG devises methods to save it or prevents over expenditure by the government. See, the money government has belongs to the public ultimately, because they have taken money from the public through various means like taxation of direct and indirect nature. So whatever money government is going to spend, that ultimately belongs to public, but it has to be spent as well. Why? Because government will do public welfare only after it has money. So public money needs to be collected and spent as well, but how it has to be spent, and whether the government is spending it diligently, or whether the government has made good use of money or not, or whether the government has lost the money, this is decided by the CAG, because he does the audit of the government. Also referred as the fourth pillar of the democracy. He is also called three pillars we have. One is uh, legislature, other is executive, third is judiciary, fourth one is, he is also referred to as fourth pillar of the democracy because he keeps a close check on the government and their spendings. He also helps Parliament plan financial activities. Whenever Parliament is going to undertake any financial activity, he will help them, like budgets, like union budget, rail budget we used to have earlier. Union budget, the government will consult the CAG whether we can spend this much money on this particular activity and what will happen. Then he will guide the government. Okay, and attorney general is for the state. He will guide the government of state for their financial activities. Appointment is, he is appointed by the president of India, but the auditor general, okay, he is not appointed by the governor of India. Auditor general, when I use the term auditor general, that means I am using it for the state only, because state has a auditor general. But when I use CAG or CAG or comptroller auditor general, that is for the India. So that is for the Union of India. He is appointed by the president of India. And other auditor generals for the state, their appointment procedure is not given in the Constitution of India. They are appointed on the recommendation by the CAG only, and they are direct subordinate to the CAG. Auditor General is directly subordinate to the CAG. States do not have their independent Auditor General. This Auditor General is subject to the recommendation of CAG. Impeachment, like Supreme Court judge, he can be impeached only like a Supreme Court judge could be impeached. In coming chapters, we'll discuss about the impeachment process of a Supreme Court judge. Okay, when I say CAG can be removed through impeachment, that means I'm talking about CAG only. Auditor General removal process is different. It is not prescribed in the Constitution, so not part of our syllabus. tenure, he has a fixed tenures of 6 year or 65 years of age, whichever earlier eligible to be re-elected as well. So his tenure is fixed tenure for 6 years or 65 years. Okay, suppose he enters the office. When he entered the office at 45 years age, then he'll have a full 6 years tenure. If he enters at the age of 62, then he'll retire at 65. That means his tenure was only 3 years. Okay, so either he will retire definitely at the age of 65 years, but otherwise if he has not become 65 and he has completed 6 years of his duration tenure, then also he'll retire and he is eligible to be re-elected. He has to ensure that center and states spend money only as per the procedure of law. He also ensures it. He'll flag it in his report. If center has violated some constitutional norms in spending their money, he'll write it down in his report. Okay, and he submits his reports. He audits the government accounts and submits his report to the President of India. He is appointed by the President of India and he is accountable only and only to the President of India. He has nothing to do with the government or any MP or any minister. Okay, he can only assist them whenever they want him to be assisted. He audits the government accounts and submits his report to the President of India, who causes his report to be placed before the Parliament. So, process is CAG will submit to President. President will send it to Parliament. Parliament means Lok Sabha, Rajya Sabha, both houses. Okay, he is also referred to as friend, philosopher, and guide to the Public Accounts Committee of the Parliament. Parliament has a Public Accounts Committee. We'll do it brief later chapters, but this Public Accounts Committee is uh, dealing with the budgeting, how to spend the government money, and new plannings of the government. Like we have new education policy right now, how much spending has to be done as per the new education policy. This Public Accounts Committee will decide, and he is called as a friend, philosopher, and guide to the Public Accounts Committee, because Public Accounts Committee will take help from this particular fellow CAG. Okay, so his report is placed in the Parliament, and then Parliament sees. Okay, Parliament means the members of opposition also can check whether the government is spending the money as per the constitution or not, and if something wrong is being done, opposition can raise this issue with the public, and then government will have to reply. Okay, Rajiv Maharishi is this current holder of the post from 2017 onwards. Rajiv Maharishi is the name of current CAG. Then we'll talk about what is Parliament of India. Article 79 of the Constitution says there shall be a Parliament for the Union, which shall consist of the President and two houses, to be known respectively as Council of States and the House of People. Okay, so this is the composition of Parliament. This is how Parliament looks
It's 2
like.
o'clock.
Okay, this is how Parliament looks like. Let me make some changes, please. So this is how Parliament looks like. Parliament is Lok Sabha plus Rajya Sabha plus the President of India. All three institutions form Parliament collectively. Now Lok Sabha is also known as House of People. Council of States is usually called as Rajya Sabha. So we'll do in briefly the features of Lok Sabha and the Rajya Sabha. Usually, these Lok Sabha and Rajya Sabha, as you see on the Lok Sabha or Rajya Sabha TV, can be differentiated from the house of the floor. The floor house in the Lok Sabha is green carpet. The floor color in the Rajya Sabha is the red carpet. Okay, it's called House of the People. Why? Because representative of the people are directly elected into this house. That's why it's called House of the People, because elections happen directly, like common general elections of India, in which everyone goes to vote, and then member of parliament is chosen. Rajya Sabha is Council of States, it is the indirect house, because in this elections happen indirectly. Okay, the chosen because elections to this particular post happen through a different procedure. Okay, MLAs vote in this election. Only MLAs of the state vote, and then, as per the counting of vote, a member of Rajya Sabha is chosen. But here, people's vote. Indirect election. Okay, because it is direct election because people directly vote. Okay, it is indirect election because in this, those MLAs which are chosen by people. Okay, people choose MLAs, MLAs choose Rajya Sabha members. That means they are indirectly elected by people. Okay, indirect elections. So maximum strength of the Lok Sabha is 552 members, 552 MPs we can have. Maximum strength is 250. Okay, 530 members come from the directly from the states. 20 members come from the Union territories. 2 members come from Anglo-Indian communities, which are nominated members. Anglo-Indian community members are nominated by President of India. So Anglo-Indian community. Usually nowadays you won't find many of the Anglo-Indian community people alive in India. Usually it was a uh, provision, or it was used nicely when India had just attained freedom, because Constitution came into 1950, and that time there were many families in India. Anglo-Indian means father is Indian. Father is like any of the parent. Sorry, any of the parent is European. Okay, because so many Europeans lived in India at that time. French were there, Portuguese were there, and then Britishers were there. So somehow it used to happen then one of them married any Indian, either a girl marrying an Indian boy or an Indian girl marrying a European boy. Okay, that means whatever child and the family lived in India, and whatever child was born known as Anglo-Indian person. Okay, so usually nowadays very less number of people belong to this community, but in order to ensure that their voices are also heard, because they are not too much in number, so there is always a threat that their voice may not be raised in the parliament, because they cannot directly by their own vote strength choose a member, because they are very less in number. So president will nominate 2 people from Anglo-Indian community. That is the composition of Lok Sabha. The composition of Rajya Sabha is maximum number of strength is 250 members. 238 members come from states and union territories. 12 members are nominated by the President of India. These are the members who have done, achieved. So, sports, music, arts, political, social, legal, medicine, etc., and other relevant spheres of life. Okay, these 12 people are nominated by the President of India. These 12 people nominate different walks of life. These 12 people are usually those who have achieved some greatness, so that they can represent that particular sport or music industry or arts or political life or social life or legal, medicine, etc. Some right now we have Shabana Azmi and her husband Javed Akhtar as one of the as two nominated members out of these 12 nominated members. These are two nominated members, and they represent the cinema. Okay, recently Chief Justice ex Chief Justice Gogoi also entered Rajya Sabha through this nomination, and he now says he represents legal and social aspect of the Indian diaspora. So the Lok Sabha is chaired by the Speaker. The chairman of the Lok Sabha is called the Speaker. The moderator of the Lok Sabha is called the Speaker, and the chairman of the Rajya Sabha is chaired by the chairman, who is always the Vice President of India. Whoever will be the Vice President of India will automatically become the chairman of the Rajya Sabha as well. Members are elected for 5 years in Lok Sabha, 5 years tenure. In Rajya Sabha, the tenure is for 6 years. Once elected, he'll stay for 6 years. Lok Sabha can be dissolved, but Rajya Sabha can never be dissolved. That's why it is also called permanent house. It is also called permanent house because it always stays in session. It can never be dissolved. Okay, we have two houses, one house which can be dissolved, other house which cannot be dissolved. It is in order to take some consideration into some emergency situation. Suppose sometime Lok Sabha is dissolved and elections are due to be held, and then there is right now no representative body in India, and then some emergency comes up, some emergency situation has come up, then who will take over the situation in the emergency times? Then that time Rajya Sabha will come to the aid, and Rajya Sabha will provide emergency services. It will make the laws, it will take the decisions for the country till the time Lok Sabha is not coming into the power. That is why we have a permanent house which can never be dissolved. That means somebody or some body of people should always be there in any case. Whenever there is some emergency or situation arises, they are always there to run the government or to guide and assist the functioning of the government. Members are directly elected in this house, members are indirectly elected. We have already discussed Lok Sabha controls the executive. Rajya Sabha has no such control. Like we discussed, executive is Prime Minister and Cabinet of Minister, and no trust motion or no confidence motion can only originate Lok Sabha. Okay, so whatever the government is doing, if the government is not acting as per the wishes of the people of India, and the parliament feels that we have to remove this government, that this removal of the government by a no confidence motion or no trust motion can happen only and always in the Lok Sabha. And Rajya Sabha has no such control or no such option in this case. Rajya Sabha can never initiate a confidence motion, nor can it take part in such confidence motion. Lok Sabha controls the executive. That means Lok Sabha will pass a no trust motion or no confidence motion in order to remove the executive. That is how they control the executive, and Rajya Sabha has no such control. Money bill, finance bill can originate in the Lok Sabha only. The bill which is called a money bill or a finance bill, which is very important bill, which we have discussed about earlier as well, and it is a very distinguishable. It is very different bill. Even the president has very limited powers in relation to the money bill and the finance bill. So money bill, finance bill can originate only in the Lok Sabha. It can never see any other ordinary bill can originate either in the Rajya Sabha or in the Lok Sabha. Okay, but money bill or finance bill will always originate in the Lok Sabha. That is our Constitution of India, it says, and then it will go to the Rajya Sabha, and Rajya Sabha cannot reject a money bill passed by the Lok Sabha. It has to pass it. Okay, it can only suggest some modifications, but if those modifications are not accepted to by the Lok Sabha, then Rajya Sabha has no power but to pass that money bill. Sessions of the parliament, both houses hold their sessions separately. Lok Sabha can be identified with the green color flooring and Rajya Sabha with the red flooring. There should not be a gap of more than 6 months between two sessions of the parliament. Okay, so whenever parliament sits in the session. Suppose they will sit for a summer session, then there will be a monsoon session, then there will be a winter session. Okay, then there should not be a gap of more than 6 months between these two sessions. That is why country has three sessions, so that to take in account the gap of these 6 months. The sessions are conveyed at the discretion of the president, and he can prorogue them. The sessions are just like we discussed in the powers of the president. He will convey the sessions. He will summon the session and he can prorogue them as well. He can cancel the session or he can cut short the session duration as well. The pending bills do not lapse with the prorogue session and it takes them up when it again assembles. So some bills which are to be passed, but suppose they are pending with the session and the session is prorogued, they will not automatically lapse. Okay, they will go up with the assembly whenever it will again assemble. Okay, but when Lok Sabha is dissolved, all bills pending for approval automatically lapse. Okay, but when Lok Sabha is dissolved, when the fresh elections are called, then all the pending bills, okay, suppose example is a bill was passed by Rajya Sabha. So we understand the normal procedure. One house passes a bill and then it sends to other for the consideration, and then when other house passes it, it will go to the President of India. So suppose a bill was passed by the Rajya Sabha and it has come to Lok Sabha. Lok Sabha is considering it, but meanwhile Lok Sabha is dissolved. There may be so many ways why Lok Sabha will be dissolved. Maybe President has dissolved it, or maybe there was a no confidence motion, or maybe the tenure has ended. Lok Sabha is dissolved, the bill will lapse. Okay, the bill will lapse. Then when the new government will come up, new Lok Sabha will come up, then Rajya Sabha will again have to repass the bill and send it to the latest Lok Sabha, and then when it will pass it, it will become a law. But however, these bills which have already been passed by the Lok Sabha and sent to Rajya Sabha for consideration shall not lapse upon dissolution of Lok Sabha. But vice versa will not happen. When Lok Sabha has passed a bill and sent it for the Rajya Sabha to consideration and Lok Sabha dissolved, then that bill shall not automatically dissolve. Why? Because the body of people, okay, the Lok Sabha has spoken it, and the Rajya Sabha, which is indirect representation of people, they will keep on functioning. Joint session of parliament. Okay, so usually parliament sits in session, Lok Sabha sits separately, Rajya Sabha sits separately, but there may be a joint session of parliament as well. Sometimes what may happen, that one bill, like in situation, one bill was sent by the Rajya Sabha to the Lok Sabha for approval, but Lok Sabha is not approving it. Okay, they have sent it back to the Rajya Sabha. Rajya Sabha again sends it to the Lok Sabha, but somehow Lok Sabha is also not approving it. But this bill is crucial to be passed. Okay, and there is a deadlock in the both houses. Okay, there is a deadlock. In order to reduce that deadlock, okay, or when other house does not take an action for more than 6 months, the president may call for a joint session. Then what will happen? President may call for a joint session, and when will the joint session will sit? All these 550 plus 250 members. Okay, it is around 800 members. These 800 members will sit jointly, and then they can pass the bill with a simple majority. Okay, and the bill will become a law. Bill will become a law. Suppose sometimes a government may not have a majority in Rajya Sabha, but it has a majority in Lok Sabha. So now it wants Rajya Sabha to pass the bill, but Rajya Sabha is not passing the bill. So now they will call a joint session of the parliament, in which now they have majority because they want only a simple majority. That means out of 800 they want only a 400 members, but somehow jointly they have a majority. But Rajya Sabha taken singly, they don't have majority, but jointly they have. So they will call for a joint session in order to pass that particular bill. In history that has happened only thrice. It happened on when dowry prohibition bill came up for the consideration, Banking Services Commission bill, and Prevention of Terrorism bill. When these things happen, then only joint sessions of parliament took place. Parliamentary committee. Parliamentary committees are, we have so many committees in the parliament, but we'll discuss only in brief, and that too some famous ones. The first one is Public Accounts Committee. It has 22 members, 15 from Lok Sabha, 7 from Rajya Sabha, and that is, it takes care of the financial expenses of the government, headed by an opposition member. It is always headed by an opposition member, so as to give a good power in the hands of the opposition, so that there is a check on the abuse by the government as well, because when it is going to be headed by the government may picture a picture the canvas in the way they want to, but when it is headed by the opposition member, there is going to be the critical appraisal or the review of the bill. So government is kept in check by this particular provision. CAG assists it, like we discussed earlier, that CAG is going to be the friend, philosopher, and guide of the Public Accounts Committee. Then there is Estimates Committee. This is the biggest committee, largest committee of the parliament, and it has 30 members. All are from Lok Sabha. Reports on the reforms of economic nature. Whatever economic nature reforms country needs, like we just had bankruptcy act, and there is moratorium on the bank loans, and so many of the other reforms of economic nature, like we had GST, we had demonetization. Okay, these estimates committee will report on these reforms. Committee on Public Undertakings, it has 22 members, 15 from Lok Sabha, 7 from Rajya Sabha. It does the accounting of public undertaking and reforms. Okay, whatever public undertakings we have, like ONGC, we have Indian Railways, petroleums we have, and whatever reforms are needed in those public undertakings, it will discuss those. These are the committees of the parliament. Then we come to the office of the Speaker of Lok Sabha. Speaker of the Lok Sabha is elected by the members of Lok Sabha by simple majority. Okay, because he is the chairman of the Lok Sabha. Speaker is kind of a chairman of the Lok Sabha. So Rajya Sabha members have no role in the election of the speaker. Just like, okay, so elected members of the Lok Sabha vote for the speaker, and the speaker is chosen, and he resigns upon the dissolution of the Lok Sabha. When Lok Sabha dissolved, speaker is also gone. He can be removed by the majority of members of Lok Sabha after 14 days notice. Removal is quite simple. Give him a 14 days notice and then go for a vote, and if majority members feel that speaker has to be removed, speaker will be removed. Functions. The functions of speaker is maintains decorum and discipline in the house, may punish a member for unruly behavior. Usually many times we see that some MPs are suspended recently as well. 12 opposition MPs are suspended from attending the parliament session or even the state assembly. It happens. Who does it? The speaker takes that decision and he suspends the MPs for unruly behavior. Power to certify whether a bill is a money bill or not. The power to certify when a bill is originated, when the government wants to pass a bill like a money bill, then they'll have to go through the speaker's route. Speaker will decide whether whether the bill qualifies for a money bill or not. If the speaker says the bill is a money bill, it has to be treated that way. Permits moving various kinds of motions like no confidence, sound motion, motion of adjournment, motion of censure, etc. Like we discussed that whenever an impeachment will originate in Lok Sabha, if the speaker decides not to pass it, then the motion will lapse. So just like it, so many other motions are there. No confidence motion, sound motion, so many motions are there. All it will be permitted by the speaker only. Decides upon the agenda to be taken up in the session. He will tell the members what agenda are we going to discuss today. Shall preside over the joint sitting of the parliament. Whenever a joint sitting of the parliament will be called, he shall preside over the joint sittings. Okay. Then we go to the another aspect of the constitution law, that is called the anti-defection law. It is contained in the 10th schedule of the Constitution of India. Nowadays we are seeing a lot of defections. What is a defection? I'll just explain you in the common man's language. It means defecting from political party, defecting or leaving the political party. Okay, suppose one MLA, one MP elected on BJP ticket joins Congress, then he will be covered by this anti-defection law. Defection means leaving of the party, and the law is anti-defection. That means it takes care of those situations in which some MP or MLA is defecting. Okay, this is applicable both for the members of parliament as well as the member of legislative assembly in the state. Provides for disqualification of a member of the house if it defects from his party and joins another party. So if an MLA or MP defects from the party and goes and joins other party, then he will be disqualified. Okay, he'll have to resign, he'll be disqualified. Exception, only exception in which case there won't be any disqualification is when one third members of the party decide to split and form a separate group. When they are forming a separate group, like political party has 100 members, and say 34 out of them form a separate political party altogether, then they won't be disqualified, because this is the exception provided in the 10th schedule of the Constitution of India. Or if two-third members decide to merge with other, if there are two-third members, suppose there are 100 members, then 76 members merge with, say, BJP. 76 Congress members merge with the BJP out of 100, then also they won't be disqualified. There will not be any disqualification. Okay, so this is quite a tough condition which these members have to fulfill in case they want to stay away from the defection law of the India. Now we go to the judiciary, judicial hierarchy in the country. We have Supreme Court of the India, highest court of land. That means we do not have any other court which sits above Supreme Court. Supreme Court is the highest court of land, and Supreme Court is for the union. Then we have High Court. This is highest court in the state government. In the state government. Then we have below this district and session judges. Then we have metropolitan magistrate or a civil judge. A metropolitan magistrate is usually can sentence people up to 7 years jail. Okay, then district and session judge can give any sentence. Okay, metropolitan magistrate can give sentence up to 7 years in jail, and district and session judge up to any sentence. High Court, Supreme Court can do anything, whatever they wish to, as per the law, whatever sentence they choose to give. Then we go for the process of removal of a Supreme Court or High Court judge. Okay, first of all, let's decide upon the appointment. Supreme Court judge. First qualification is citizen of India. Must be a citizen of India. No age qualification is there. But because the retirement age is so, though no minimum age is there for the appointment of a Supreme Court judge, or maximum age for Supreme Court judge for appointment, but the retirement age is 65 years. So at the time of appointment should not be 65 years, because 65 is the age at which he retires. Must be a citizen of India. Must have been advocate for at least 10 years. Okay, or must have been a High Court judge for 5 years. Okay, this is the qualification for the Supreme Court judge, and similarly all same qualifications for the High Court judge, but his retirement age of a High Court judge. Appointment of a High Court judge. He must be a citizen of India and must have been an advocate for at least 10 years, and retirement age is 62 years. So when he is appointed, someone is appointed as a high court judge, he should be less than 62 years, because 62 is the years when he retires, and should have been an advocate for 10 years, same like Supreme Court judge, and must be a citizen of India. These are the qualifications for appointment to the Supreme Court and the High Court. Then we go to the process of removal. Process of removal of the Supreme Court and High Court judge. Both of the judges, both Supreme Court as well as High Court judges, could be removed only through a similar procedure, that is called the procedure of impeachment. Impeachment, just like in the case of the President of India, impeachment process will happen only on the case of violation of the Constitution. In the case of the impeachment of the Supreme Court or High Court judge, it will happen on the basis of proved misbehavior or incapacity. Misbehavior could be broadly categorized as can be broadly categorized as anything which is not as per office requirements. Okay, anything which is not as per the requirements of the office. Okay, suppose takes bribe, okay, or make some recommendation which is not as per the law, or abuses authority, etc. Okay, so this proved misbehavior is a very broad term, and so many abuses or so many misuses of authority can come into this bracket. Or incapacity. Incapacity may be, suppose that he has become insane or physically challenged now in such a way that he cannot be a judge, or there's old age related issues, mental issues like this. Someone may not be insane, but maybe like he may have a very short memory now, okay, such as short memory or loss of memory. Okay, that means the person will become incapacitated for being a judge. Okay, so proved misbehavior or incapacity. So just like impeachment motion by at least 100 members. If impeachment is happening in the Lok Sabha, it has to be signed at least by the 100 members. If it's happening in the Rajya Sabha, it should be at least by the 50 members, just like President of India. Okay, one fourth people. If the speaker of the chairman, so in whatever house it has originated, if it has originated in the Lok Sabha, then speaker. If Rajya Sabha, then chairman accepts it. If they accept it, then the three-member committee shall be constituted. Okay, if the chairman Rajya Sabha does not accept it, reject it, okay, if the chairman or speaker rejects it, then the impeachment motion shall lapse then and there at this stage only. Okay, but if they choose to go forward with it, three-member committee shall be constituted. Okay, three-member committee shall investigate the charges. Now, this committee shall investigate the charges upon the judge. What charges? Whether he has done some misbehavior or whether he has contracted some incapacity. Then, if they found, if this community if upon the investigation, if the judge is found guilty, impeachment motion will start. In impeachment motion, what will happen? It must be passed in both houses by a special majority. Like first it will be passed in Rajya Sabha, then in the Lok Sabha by a special majority. Special majority means 75% of total strength of house. Okay, if they pass it, then president will sign the motion and judge will be removed. This is the course of the impeachment of the Supreme Court judge. However, no judge has ever been impeached in India. The most near to impeachment was Justice Soumitra Sen, but he resigned just before president was due to sign the impeachment. Okay, so this Justice Sumitra Sen was actually impeached, but when this impeachment was sent to the judge and sent to the president for signing, and before president was about to sign it, he gave his resignation, and that is the rule. When judge has given a resignation, he cannot be impeached, but he will be removed like a resigned judge. Okay. Then we come to the emergency provisions of the Constitution of India. Constitution of India has given some procedures for the emergency as well. Sometimes it declares that there can be three type of emergency in the national emergency means Union of India as a whole, for whole 29-30 states. Okay, state emergency means for a state emergency it gives three situation in which there could be emergency in India. Imposed emergency: war, when we are at war with some country, like we have been at war four times, thrice with Pakistan and one time with China. Okay, so when country is going through a war, then there will be national emergency. External aggression, it is just like war only. Okay, just like a situation like World War III kind of situation. This war is like one war with one country, but external aggression is like war with so many countries at the same time. So it is just the elder brother of war, or when there is an armed rebellion within the state, within the India. Within India, if people have taken up arms, like we see in so many countries nowadays, citizens have taken up arms and ammunitions, like it was in Syria. Okay, it was in Syria. Then, in that case, national emergency can be imposed. Emergency has been imposed only once in India, that is by Indira Gandhi in 1975. After that, we have never seen emergency imposed for this kind of national emergency. We have never had this emergency in India, only once by Indira Gandhi in 1975. Procedure for the national emergency is PM and Council of Ministers must make a written recommendation to the President of India. Okay, Prime Minister and the Council of Ministers jointly they will make a written recommendation, written, not oral. So many things can happen orally as well, but in the case of emergency, they must make a written recommendation to the President of India. President is not bound to sign it, but upon satisfaction, if the president feels that yes, there is actually a situation of emergency and whatever PM and Council of Ministers are saying, I must sign it, he will sign it and he will proclaim emergency in India. This proclamation must be laid before the parliament within 30 days of issuance. So suppose on 1st of June emergency is proclaimed by the president, then before 1st of July, this proclamation should be put before the parliament. Parliament means both houses, Lok Sabha and Rajya Sabha. Then both houses will pass it with a simple majority. Okay, if it is not passed within 30 days of the proclamation, then emergency will lapse. Okay, if it is not laid before the parliament, it will automatically lapse. If the parliament does not pass it, then also it will lapse. But if parliament passes the proclamation of emergency, it can continue without further approval for after 6 months. It will remain in force for another 6 months, and after those 6 months, again within 1 month, they'll have to seek reapproval from the parliament. This is the way this emergency could be imposed and continued. Fundamental rights except Article 21 may be suspended till emergency. Right to approach court cannot be taken away. So many of the fundamental rights like right to speech and this and that can be suspended, just like they have been suspended in the state of Jammu and Kashmir right now. Okay, and right to approach cannot be taken away, but right to approach the court, if something has happened wrongly to you, and you can then you can approach to the court. State cannot say that from nowadays till the emergency is imposed, court shall remain closed and no one will have right to approach a court. No, that right cannot be taken away. Okay, but otherwise all articles can be taken away. There may be no right to equality or no right to freedom, that particular no liberty may be there, but Article 21, that means you will have a right to life, shall always be there. State cannot kill you in the name of emergency. Writs may be suspended. We have discussed what are the writs. So meanwhile, for a short duration of 2 months or 6 months, because emergency is not going to be always there, it has to be repealed. So meanwhile, writs may be suspended, and you can revive the writs later on when the emergency is lifted. Then the second kind of emergency, we have state emergency. State emergency is when it happens due to failure of constitutional machinery in the state. The state is acting in such a way, the manner of affairs in the state is such that the governor feels this will happen only on the recommendation of the governor. Okay, when the governor will recommend that constitution machinery is in such state in the this particular area that we cannot say that constitution is fully functional there. So he will make a written recommendation to the President of India. Okay, written recommendation of the governor. Governor will write to the President of India, and then President may not act upon that recommendation. Act upon that recommendation. Okay, if the president does not act upon that recommendation, nothing will happen. If the president says that yes, I accept the recommendation of the governor of the state, that particular state, and impose an emergency, just like recently emergency was imposed in state of Maharashtra. Okay, during this emergency, all the laws of the state will be taken, all the administration will be taken upon by the union. During this period. Okay, and each self proclamation, every such proclamation must be approved by both the houses within 2 months, otherwise it will also lapse. State assembly is kept in suspended motion. State assembly does not dissolve, okay, upon emergency. It is always suspended only. State assembly will be dismissed only after the approval of the parliament. But if the parliament feels that state assembly has to be dismissed, it will be dismissed. Okay, automatically it will not be dismissed. So this is the state emergency. Then there is a financial emergency. Whenever there is a threat to the financial stability or the credit of India, it has never been involved, never been imposed. We have never faced a financial stability or financial emergency in India. The most close situation was in year 1990, when India's credit has gone down to unexpected levels, and we had very financial instability, and we had taken a huge amount of loan for the World Bank to remain stable. That situation is said to be the most close situation to the financial emergency. Still, financial emergency officially was not declared. We go to the election commission. We have an election commission in India that is comprised by chief election commissioner and two election commissioners. That is, there are three election commissioners in number, three in number. Okay, total three election commissioners are there, out of which one is chief election commissioner and two are election commissioners. They all have equal powers. It is not that we are calling him chief election commissioners, that means he will have more powers over other two election commissioners. No, all decision making is by majority always. Okay, so suppose some decision is to be made in which two election commissioners say X and he is saying Y, then X will survive. Okay, it doesn't mean that election commissioner is saying something then it will automatically be upheld. No, decisions will have be done by the majority always, and all three have equal powers. Removal by the CEC by impeachment only. Okay, removal of CEC. When I say CEC means Chief Election Commissioner. Chief Election Commissioner can be removed only by the impeachment by the President of India. We have understood the process of impeachment quite in detailed manner now, so it is a very difficult procedure. Why we have given these impeachment powers? See, these impeachment powers, removal by impeachment, only to people having significant posts. Okay, like president, SC, judge, CAG, CEC. Okay, these people are performing really very significant and important functions in the democracy. High Court judges and Supreme Court judges are keeping a check on the government, okay, so that there is no harassment. President is keeping a check on the parliament so that there is no harassment of these people and unnecessary removal threat is there, no blackmailing for removal is happening, and so that they can function independently. A difficult process of impeachment is provided for these functionaries like CAG, okay. So CAG is the guardian of the public purse, so that tomorrow he is not removed and government is not abusing the finances of the country. That is why CAG is there. Similarly, Chief Election Commissioner can be removed by impeachment only. Why? Because he is the one responsible for conducting the free and fair elections in the country. Okay. What is the function of election commission? Usually preparation of election rolls, conduct of all elections in free and fair manner up till the level of the president of India, recognizing political parties, allotment of symbols. So it has very deep functions as far as the government is related, okay. So his removal can happen only through impeachment, and removal of an election commissioner can happen only by the president upon recommendation by the CEC, okay. So impeachment is exclusively for the chief election commissioner, and out of these two election commissioners they can be removed by the president of India upon the recommendation by the CEC, okay. Like when Naveen Chawla was an EC means simple election commissioner, his recommendation for removal was made by then CEC, okay. Just like because the CEC can make a recommendation to the president for removal of EC, but president did not agree, okay. So president may or may not agree. That case president did not agree, and Naveen Chawla later went on to become the chief election commissioner. Official languages, there is a part which says official, talks about official languages as well, okay. So there are 22 recognized languages in India. When I say recognized languages, I do not mean to say official languages automatically. 22 recognized languages means the constitution of India recognizes these 22 languages as, yes, that these are the languages which exist in India and they have a national importance only. But when we talk about official language, Hindi in Devanagari script, okay, this should be, I should bold on this and undermark this as well. Hindi in Devanagari script to be the official language of the parliament, okay. The constitution says the Hindi in Devanagari script, okay. If we say Hindi only, it is not right answer, but Hindi in Devanagari script, because way of writing is also very important. Hindi in Devanagari script to be the official language of the parliament. For union government, Hindi is the official language, okay. So many people do not know it, but Hindi is the official language. But somehow, because we were ruled by the English people and our parliament was functioning in the English, so an interim provision was entered that English will continue till the time it is replaced by the Hindi, which till today it has not happened, because English is very dominant language in the world. So nowadays, so now we use Hindi and English both as official languages, but however only official language is Hindi, but English is used, okay. But for Supreme Court and High Courts, English is the official language. And official languages of the state shall be chosen by the state only. So, like Tamil Nadu may have their own language as the state language. Tamil may be a state language. Amendment to the Constitution of India, Article 368 is there, which says that Constitution can be amended as well, like we discussed, okay. That Constitution framers made a house and then they put a lock over it and gave the key to the people of India. If you want to make changes in that particular house or that structure, yes, you have the key, you can open the door and make the changes, okay. So changes could be made. Amendment, modification or changes is the same word. So amendment to the Constitution of India, if you want to make changes in the Constitution of India, that can be made by three ways: simple majority, special majority, or special majority and ratification by the one and a half state, okay. So we'll discuss. It is like simple majority is simply by both houses of the parliament, yeah, amend, passing it with 50% rule. Okay, 50% rule. 50% rule means whichever side has 51% votes in its favor, the law is passed by the simple majority. So if you want to make basic change, very normal changes in the constitution, simple majorities need only 50%. Special majority, some rules are very relevant. Okay, some important rules are there. We'll not deal with them right now. Okay, they are very detailed part of the constitution, but we'll discuss only about types of majority. Special majority is 75% votes you want, votes in favor. Okay, so both houses of the parliament will sit and they'll pass it with the special majority. Then only that amendment will come into operation. Then the most stringent or the most hardest amendment way of amendment is some very crucial features such as fundamental rights. If you have to change them, you need special majority and ratification by one half of the states. That means 75% parliament will vote in favor, and half of the states, like we have 30 states, then at least 15 states, 15 states, we have 29 states, sorry, so at least 15 states should also pass law in favor. Then only this majority or this amendment will come into power. These are the constitutional safeguards which have been placed in by the founders of the constitution, so that yes, you can make the changes or amendments to the constitution of India, but amendment has to be done in either three ways. So some basic normal changes you want to make, you can do it through simple majority. If you want to make some changes which are having wide ramifications, you go for special majority. If you are going to make to the changes to the core of the constitution, you go through this particular route. But however, whatever be the case, you cannot make changes to the basic structure of the constitution. Okay, basic structure, like I said, constitution has given us a, framers have given us a house. We can make changes to the window, we can change the pattern or the colors of the wall, we can add new walls to it, or we can remove some windows or something like this. We can do, we can add floors as well, but we cannot remove the pillars, we cannot take away the foundation, the whole building will collapse. So basic structures, basic features are those. Basic structure is those features without which the constitution shall not survive. Okay, it was said by the Supreme Court of India in Kesava Nanda Bharti case. Okay, it is a very celebrated judgment, came in 1973, Kesavananda Bharti case. Biggest Supreme Court bench sat there, 15 judges, and it was, judgment was passed in the majority of 7 into 6, very thin majority, 7 people, 7 judges voted in the favor, 6 judges voted other than this case in the Bharti case. So this was the highest bench which sat there. Okay, 13 judges bench it was. So Kesavananda Bharti judgment says basic structure you cannot take away. Some example of basic structure is like our country is a democratic country. Tomorrow constitution cannot change it to a military rule. It will take away the constitution itself. The constitution will collapse. So you cannot say this country is a secular country. You cannot make it a Hindu country. It will be the violative of the constitution. This amendment, though even passed by the most special stringent rule, okay, even if it is passed by this rule, then also this amendment will not be valid, because it takes away the basic structure of the constitution: democracy, Hindu country, republic, sovereign, equality. These are the basic structure of the constitution. You cannot take them. Basic structure list is a very wide list. You can have many features into it, so we will not go into that list nowadays, right now, but you just understand what is basic structure, something which will take away the constitution itself. Okay, which will change the constitution itself. You are not making an amendment in the constitution, but you are changing the constitution as a whole. No, that is not allowed. Then we have schedules of the constitution. We have almost 12 schedules of the constitution. We are not going into the detail, but we are just having an overview. First schedule is territorial demarcation of the states and union territories, how Tamil Nadu's boundaries are decided, how Gujarat's boundaries are decided, that is given in the schedule 1. Provision of the president and the governors, what is president and what are the governor, what are their powers, what will they do, this is provided in the second schedule. Third schedule is form of oath and affirmation. You must have seen when any minister takes over, then he is given an oath that I, in the name of so and so, shall discharge my duties in that and that way. This oath is given, this oath and affirmation forms are given in the constitution third schedule, and president will read it and then the other person will read it. That is called the proper oath. It is not that you will take oath in any other form. No, you have to take oath in the forms given in the schedule 3 of the constitution of India. Allocation of seats in the Rajya Sabha, how seats have to be allocated, like how much seats will Tamil Nadu have in the Rajya Sabha, or Gujarat have, or Rajasthan have, that is provided in the fourth schedule of the Constitution of India. Provision of administration and control of scheduled tribal areas like Assam, Tripura, Meghalaya, these areas are scheduled tribe areas. How you have to administer them, what is the control of president and governor over these area other than their own government, that is given in the schedule 6 of the Constitution of India. Then schedule 7 we have, it talks about three lists. One list is union, state and concurrent list. Union, first list is the union list, second list is the state list, third list is the concurrent list. Union list means this there are like 97 66 entries, I guess. There are some entries okay, maybe 96 entries in the Union of India, where only only parliament can make laws. Then there is a state list in which only state can make laws in that th- those areas. Okay, then there is a concurrent list, that means in which both state as well as union can make a law. Like I'll give you an example, like agriculture. Agriculture is a state subject, so if law, any law has to be made by the agricultural income, that will be made by the law. Okay, official languages, there are 22 official languages like we just discussed. So please don't confuse this agriculture with the farmers bill right now. Okay, that is a total different bill, and that entry is with the union. Okay, so union will make law in that behalf. Here we are talking about only agricultural income. Laws saved from the judicial review. Schedule 8 is official languages, that is we have 22 recognized languages. uh, then we have schedule 9, which says laws saved from judicial review. It is a compendium in which some laws are placed on which no judicial action can be taken. Then schedule 10 is anti-defection law. No one can leave a party and join another party without facing disqualification. Schedule 11 is provision of panchayat. We have panchayat in India due to schedule 11. Then we have schedule 12, which provides for municipality, that is urban governments. Okay, next part we'll do sample questions on the Constitution of India.